much as this is the time when you enjoy the fruits of judgment, at times execution process can also turn to be tragic. It can turn to be very ugly. Execution process can bring with it challenges which may even lead to loss of lives. I think that is just a different page of execution. But for a successful litigant, execution process is the time when somebody enjoys the fruits of his judgment or a judgment. And that is why I say it is a very important stage. This is a very, very valued stage for a successful litigant. But as I've said, this execution process can at times turn to be very bitter. It is a bitter-sweet stage or a sweet-bitter stage, depending on what happens. Execution is recognized by the law of this country, and that is why when you look at Section 44 of the Civil Procedure Act, it says very clearly, so long as you are a successful party and the court has made an order that you should pay or you should give or you should surrender something to the successful party, the execution process can commence. What can you execute against or what can you execute upon? Section 44 of the Civil Procedure Act allows execution against the JD. What are some of the things that you can execute against? You can, for example, execute immovable property, that is land. You can execute movable property, motor vehicles. Those are the things which would concern auctioneers most of the time. You can attach money or property belonging to the JD which is elsewhere else. For example, money in a bank. You can attach salary and several other things. But I know for purposes of this meeting, we're going to concern ourselves mainly on attachment or execution against movable and immovable property. I have said this is well provided for under Section 44 of the Civil Procedure Act. There are, of course, exceptions when it comes to execution. Prominently, you cannot attach tools of trade of a person. I don't know whether I should pose a question to the plenary, but maybe this is what is going to come up in the afternoon during the question answering session. You're not supposed to attach the tools of trade of the JD. When we talk about tools of trade of a judgment debtor, who in particular are we referring to? Who are we referring to? Let's say we're talking about an insurance company. An insurance company ordinarily would have a computer, it would have chairs, it would have maybe stationery. Those should be tools of trade for an insurance company. But does Section 44 exempt attachment or proclamation and subsequently attachment against computers, against stationery which are used by an insurance company? Does it? Of course, the answer is no. People who are exempted on execution or proclamation and attachment on tools of trade are only individual persons, people like artisans. So companies, corporate bodies are not exempted. This has been subject to interpretation by the court. Later on, I want to apologize because I'll not be able to give you a piece of what I'm presenting because of the short notice. I've been preparing it, it's not finalized, but when it's finalized, I'll pass it to Mr. Kimani, who should be able to email to all of you to do whatever he can do so that we can get copies. This has been subject to interpretation by the High Court, and Justice Bosire, while looking at this issue, at some point in time in the authority that you're going to see in the right that I'm going to present to you later on, said that tools of trade only refer to tools of trade to an individual person like an artisan, so that corporate bodies, which are companies, are not exempted from being attached against on their tools of trade. Ladies and gentlemen, Section 44 of the Civil Procedure Act, as I have said, provides a list, a raft of items which are exempted. Some of the things, of course, which are exempted also include books of accounts, of the JD, you're not supposed to attach books. If you are attaching salary, and rarely would you be attaching salary, but if you are to attach salary as auctioneers, you're not supposed to attach 2/3 of the salary of the JD. If you're talking about an agriculturalist or a person who does agriculture, there are exemptions on what you can attach. You will get my write-up and you will get to know fully really what you can attach and what you cannot attach, what can be proclaimed and what is not supposed to be proclaimed. The meaning of tools of trade, for example. I said execution process as it is can be bittersweet. If you proclaim, you attach, and the JD responds very well and issues a check, or the land is attached successfully, the successful party and the advocates and the auctioneers would have every reason to rejoice because they are going to be professional fee. But there are occasions when you proclaim and attach and it turns out to be sour. It turns out to be a misfortune. For example, when it comes to attachment of movable properties, I'm not going to talk about the proclamation, notification of sale and those other things. I want to talk about identification. Who should identify for the auctioneer? Section 34 of the Civil Procedure Act gives this power, or rests this power to identify squarely on the shoulders of the JD. On the decree holder, sorry. It is upon the decree holder to identify what is going to be proclaimed and attached. But as you know, and most of the times, most of these decree holders are represented by advocates. So that at the point of identification, it is possible that it's a law firm, a firm of advocates, which is identifying the property to be proclaimed. And as I said, this is the stage where you enjoy the fruits of judgment. This is the stage when everybody now goes to rest. That is the successful party. And people who are assisting the successful party, this is the time when you go to rest, especially when you've been given your necessary remuneration or professional fee. As I said, it rests squarely. It is within the shoulders of the decree holder to identify. But you may find, and this is what happens most of the time in practice, you find a law firm or employees in a law firm relating and cooperating with the auctioneer to identify. And in a number of occasions, you identify wrongly and you execute wrongly. When you look at the trend at the moment, I must say that much as I'll be telling you later you are immune as officers or as agents of the court, there is an element of diligence, there is an element of care, there is an element of reasonable skill expected of auctioneers. You're not absolutely immune from wrongful attachment. You're not absolutely immune. A case in mind, for example, is a case in Kisi, where auctioneers executing court orders were supposed to attach some cows. I do not want to mention the parties in that case because it could be possible that maybe one of the auctioneers is seated with us here. But of course, there's no problem. I think that would be a living example. It would be a living example of citing a practical example. They went. I think they did the proclamation. These were cows. Later on, of course, 4 of the 30 or 20 cows which were taken away belonged to other people who are not the judgment debtors. It is possible, and this is what I get from the judgment of the Court of Appeal. The auctioneers may not have known at the time they took away the cows, that these cows belong to different people. But they were informed. When they were informed, they were still keen on proceeding with the sale. They sold these 4 cows which belonged to wrong people who objected successfully. When this matter went to the Court of Appeal later on, it went to the DR, it went to the High Court, it went to the Court of Appeal. The Court of Appeal was saying, see, there were these objection proceedings. The owners